Okay, it is the noon hour. Welcome to the Legal and Ethical Campaigns for School Board members. Today is Wednesday, September 3rd of 2025. My name is Anna Harmon. I am the Policy and Legal Services Director here at IASB and will be facilitating the webinar today. Marty, would you like to introduce yourself?
You bet. I'm Marty Brightman, a legal services specialist with IASB, and I will be monitoring the chat and reading those questions aloud for our presenters.
Yeah, so thank you all for attending and for your interest in running for school board, serving as a school board member. Today, our plan is to inform you on campaign laws, conflict of interest laws, gift laws, etc., and then kind of help you understand how to run legal and ethical campaigns. So for those of you joining us live, as this will be a recording and accessible on our website, the IASB website, please maximize this opportunity to learn by sharing your questions, as Marty said, with us through that chat application. And it looks like we've had a few people test that already. So glad to see that's working. We'll monitor those questions and try to come to those or get to those as they come in if they're relevant to the topic. Otherwise, we will have time at the end of the webinar to answer those questions. Otherwise, IASB's communications team is the primary contact for community members that are interested in board service. So, yeah. I would like to now offer a warm welcome and thank you to our experts in the room who will be presenting today. Erica, if you wouldn't mind introducing yourself, then we'll pass that on to Bailey.
Hi, good afternoon. I'm Erica Eckley. I'm the Executive Director and Legal Counsel for the Iowa Ethics and Campaign Disclosure Board. And I think I'm tossing it over to Bailey for her to introduce herself.
Hi, everyone. I'm Bailey Kelly. I am the Director of Elections for the Iowa Secretary of State's office. So I think maybe to preface all of this conversation, I handle election administration, which is done by the county auditors. And Erica is going to be the expert on the campaign rules. But I'm here to provide guidance about how to be a candidate and navigate that. But we kind of in Iowa, we have a situation where it's two different offices that handle this.
Yes, thank you. So we'll go ahead and get started. Review some of the goals for today. So review key dates. We're going to master the basics of filing, learn about conflict of interest, discover 3 must-know campaign finance laws, explore an ethical scenario, and in this case, we'll ask the audience to do some thinking on their own. And then here's some cautionary tales from both Erica and Bailey, and that'll be that practical application of everything we learned today. So before we really dig into that, we'd like to get to know our audience a little bit better. So we'll be launching a poll. You have 6 options here of where you are either in the campaign or where you are thinking about whether or not you're going to start campaigning, or if you're a board member, superintendent, SBO, or otherwise. So Marty, if you would launch that poll, please. We'll give you a few moments to read the options. Okay, it looks like we have 87% participation. A lot of I've decided to run for the school board. Congratulations. Current school board members, this is always a good time to review. Actually, we have a pretty decent mix. So everybody, welcome and thank you for attending. Okay, moving on. So now we'll pass the webinar off to the experts in the room by speaking about key dates.
All right, so the filing window is open for school board candidates. You will be filing with the school board secretary. I know that for city school elections, it can be a little bit confusing because for most elections, you always file with the county auditor. For city elections, sometimes they designate the city clerk to be that filing officer, sometimes they don't, but it's very clear in Iowa code that for school elections, the school board secretary is the filing officer. She'll be filing with them. It is 5 p.m. on September 18th. And if something changes in your life and you decide that you don't want to be on the ballot anymore, then the withdrawal deadline in writing is 5 p.m. on the 23rd. This is something that happens. On a much larger scale, I had many conversations with the Robert F. Kennedy Jr. campaign last year because they did not want to appear on our ballot and they did not notify us by the withdrawal deadline. So he was there on the ballot if anybody voted last November. So that withdrawal deadline is important. Election day this year is November 4th. And then canvassing the votes, that is the process where the board of supervisors for each county that's involved will review the results and certify them. So tier 1 means your board is looking at all of the precincts within your county and that jurisdiction. But if you are in a school district that crosses counties, then you have your first tier canvass where they certify those votes on November 12th, and then they notify what we call the control county. So like the county that has the most taxable base for your school district. Then those other counties that kind of trickle in, they will report back to the control county and let them know what their results are, and then they perform a second tier canvass, which is the final decision in who is the winner of that election. And they produce documents, and they will contact the winners of those elections, and then they will get them sworn in.
All right. So now that we have kind of a baseline of key dates and deadlines, the very first steps for a candidate is to learn about filing and to understand about those, or to learn about those potential conflicts of interest that may prevent them from running for school board in the first place. So once again, I will turn it to our experts and let them dig in.
So the very last bullet point here is a link to our website, which will have a very, very helpful candidates guide. And that will include all of the information that I'm about to spew out to you. It will have links to the affidavit paperwork, the nomination petition paperwork. It'll have the dates and deadlines that we just went over. So make sure that you are going to this website and getting that information from our office, because it's going to be the most accurate, the most up to date, and you just read through it. It's about 20 pages, I want to say, maybe less. So it's not a daunting document by any stretch. So you have that available to you. But the important things to remember is when you go to file with the school board secretary, you need to make sure that you have your affidavit of candidacy and your nomination petitions together. You can't turn in your affidavit and then say, oh, I'll bring in the signatures when I get them. They have to be together. Make sure that your affidavit is notarized. Your county auditor's office will have free notary publics. Sometimes the school board secretary may be able, they may potentially be a public notary, and so they could do that for you, but it's just a good idea to have that done in advance. If you are in a situation, this typically doesn't happen with school boards, but if you're gonna have somebody drop off your paperwork, you need to absolutely make sure that it's notarized beforehand, because you can't just sign something and then have somebody notarize it. The entire point of a notarization is I witnessed this person with their ID sign a document in front of me. So the notarization part is important, but it should be easy to do. Like I said, all of your county auditors are notaries. They can help you with that. And a lot of your school board secretaries will be as well. Again, filing deadline is 5 p.m. on the 18th. Signature requirements. I did see something in a chat. Does a signature count on the petition if they abbreviate the town name? And the answer to that is mostly. If you have, right, so I'm in Polk County. When the Polk County auditor receives petitions and they say WDM or DSM, they know what that means. That's plain and simple. So of course, yeah, those would be as acceptable. The tricky part is if you are in a jurisdiction where you have two places that could potentially have the same abbreviation. So, right, you have a Pleasant Hill and a Prairie Heights, right? They put down PH. And you can't figure out based on the address which one they're talking about. And one of them is in your school district and the other is not. That becomes a problem. But just simply using WDM for West Des Moines, that's perfectly reasonable. And again, in that candidate's guide on our website, it has the signature requirements. So for school board candidates, you will probably have to reach out to the county auditor to get the numbers that you're going to need, because it's based on turnout at previous elections and things like that. So you will have to do some discernment of how many signatures you need. But we always recommend that you go above and beyond, get more than you need. You never want to be the person who has 101 and then to get crossed off the list. So I think I'm good here.
All right, thank you for that. And I will second that that campaign guide. It is fantastic, and I myself has referenced it several times. So highly recommend looking at that. Marty, we have another poll for the audience. So given all the information we have just processed, where are you at in the filing process? So we have 3 options here: already turned in the paperwork, collecting signatures now, haven't quite decided yet if I'm running, or other. A few moments. Right. Kind of looks like everybody's evenly all over the place. So already turned in paperwork, collecting signatures, and quite a few others there. So, yeah, thank you for sharing that information. Okay, so conflict of interest laws, we're going to go ahead and pass this back to the experts again.
So I can cover this. The Iowa Ethics and Campaign Disclosure Board, we focus on Chapter 68A and 68B. So I'm going to focus on those areas, but I want you to make sure that you are cognizant of the additional conflict of interest laws in other parts of the code as outlined here, such as the prohibition on receiving more than $20,000 in compensation, appointing a relative within a third degree of relationship to a paying position without approval by the board. The key areas of 68B highlighted here are you have to ensure that you're not taking official action or performing an official duty with outside employment or activity. Specifically, the code prohibits an individual from having multiple jobs, getting that would conflict with each other. So if you have a state or local government job, you can't receive payment from outside sources to perform that job. Your payment would come from that local or state government official. You also cannot utilize your government time or efforts, your government resources to perform that outside employment. So you need to keep that in mind as you're considering running and what that might mean with a position that you might be elected to. The other thing that you need to remember is that you can't have a position that would conflict with something that you might have authority over. For instance, with the Iowa Ethics and Campaign Disclosure Board, we have authority over other state agencies. We have authority over candidates for government office. So I would be prohibited from being on a board of a different state agency that I would have authority to review. Would be unable to participate as a candidate because of my government position having authority over those. So that would create a conflict where I wouldn't know where my loyalties lie, and it would create some issues. So that's why the law prohibits that. I will say that on the local level, these ethical issues are enforced by the local authorities. So the county attorney or others would have authority over those. We do help provide some guidance and some review on that to assist with that, but any actual enforcement of that would come from the local level. The other area that can really cause some issues is the gift law. Iowa has a very strict gift law to prohibit any of these conflict. The whole point of having the gift law is to ensure that the decisions that are made as an elected official or as a government employee is that they're being made on behalf of the government, on behalf of the people, and they're not being unduly influenced by individuals who might be trying to provide additional gifts or favors to individuals who are making those decisions. So, for instance, if you are on a school board, you cannot take gifts over to $3 from anyone who would be a prohibited donor. This would include somebody who might be looking to have a contract with that state or with that school board. They might be looking to help provide some construction. There might be individuals who it impacts their employment. So individuals who would benefit from decisions made by that school board should not be providing gifts to individuals. There are, of course, some exceptions to things where there is little concern with that. These primarily include, if you're participating in something that the general public would be at, where they would have the same rights to receive or participate in the event. If there's, if you have a family member or something like that that is related to you. So very limited situations there. But the whole point of that is that it helps the public understand and have ensure that they are the decisions are being made for the benefit of that government body rather than because somebody is going to be benefiting personally from that decision. So keep that in mind and be very cognizant of that. If there is a concern, you're always welcome to reach out to us and talk with us about anything before there becomes a problem. But just keep in mind, even if there's something that maybe is on the line, just the appearance of impropriety there can sometimes cause some issues for people. So keep that in mind. The other
Erica?
thing, yeah, I'm sorry.
excuse me, we do have a question from our
Sure.
audience. Would be taken out to dinner from a construction company be considered a gift?
I would consider that a gift. You are receiving something of value, the cost of that dinner. That construction company, with the school boards, my local school has been, my local school district has been doing a lot of construction and updates with their schools. So being taken out to dinner from those construction companies could create that conflict of, they're taking you out to dinner, they're trying to create that relationship. So that would be something that would not be appropriate to do. Um, again, I think I saw that it said could a college provide a gift to them? Again, that one probably it depends on, what that college was doing. Are you encouraging people to go to that college? Are you doing some additional things? So, keep in mind why is that college providing you those gifts? So think about that. Are they sending it to everyone in your district? Why are they sending it to the school board? Just without knowing exactly how much that was, if it's a $3 item or less, you're probably all right. But if it's something a little bit more, why are they sending it to the school board? Are they looking for you to be making some decisions to assist them? Are you offering college credits? Think about the decisions you're making and what relationship there is with that college. Just looking at that without more information, I would really flag that as possibly something of concern because I don't know if that school district is sending students to college courses with some of their funding. I don't know if they're helping provide scholarships, if they're doing something to benefit that college. So just kind of consider that. Uh, so I wasn't quite sure. I didn't quite catch it if that was just an addendum, if it's the college's own board, they're providing gifts to them. That would be, if that would be like your employer giving you something. So just keep in mind, it's the gifts from the prohibited donors, people who stand to benefit from the decisions that you make or the investigations that are done or those types of things. So keep in mind, is this gift coming from that prohibited donor, or is it coming from somebody completely unrelated to the decisions that will impact the others?
Okay,
Um,
great questions. Oh, go ahead, Erica.
And then expending or permitting the expenditure of public monies to expressly advocate in favor for or against a candidate or a ballot issue. We get a lot of questions on this, and we're more than happy to help. So there is a prohibition, the 68A .505 in the code that prohibits using resources. This would include not just money, not just a budget item, but also your time, your phone, your copies, and any kind of resources. If you're doing something at the job, your state or local job, that would be considered your expending public resources. And when we talk about this, there needs to be that express advocacy. And so this would include, for instance, we're seeing quite a few ballot issues for local option sales tax or bond issues for school districts to improve some of their buildings or other things like that. The thing that makes it an express advocacy is if you're taking a specific position on that issue and you're asking people to vote in favor of it. So for instance, just providing some general information, there's going to be a bond issue on the ballot on September 9th. This would not raise your taxes, but would bring in $1 million to the school district for this. That does not specifically advocate for or against it, so that would not be prohibited. The issue comes in where you say, we support this ballot issue. We encourage you to vote in favor of it. So we're looking for magic language of support, vote for, cast your ballot in this way, and things that are directing people in how you want them to act rather than just providing information. We've had several school districts reach out to us with some information that they wanted to provide about dates of ballot issues, dates that they would be on the ballot, specific information about what, how much it would be, how it would impact, but it didn't include any of that specific, please support this, or vote in favor of this, or we ask you to vote yes on November 4th for this issue. So long as you are not expressly advocating, not asking them to vote a certain way, you can provide information. But if you are saying, we support these candidates, we support this issue, those are things that you cannot in any way use government resources. You can't use your phone. You can't do it during your time, and you certainly can't send out mailings from those public funds. So those are things to keep in mind.
I just want to, sorry,
Yeah.
jump in and underscore what Erica just said about the express advocacy. It's also a very slippery slope when even you're just putting information out there. If you start throwing graphics into a document or highlighting specific things, I mean, that can all be interpreted as maybe even an unintentional advocacy for something. So really, if your school is going to do any kind of public education about a ballot measure or a school board race, just really stick to the facts. It gets very tricky. You know, all communication has a message. So if you're going to put out any kind of information to the public, my recommendation would probably be to leave it to the county auditor's office, who's going to be running the election and administering it and putting it out in the newspaper and everything like that. But yeah, you certainly can notify the public, but as soon as you start throwing an exclamation point here or you know, telling people about, you know, stick to what your public measure actually says. This is what it's going to be used for, as opposed to, wouldn't we all like to see a new gymnasium? This one is terrible. Like, that's where you kind of start getting down that path of maybe unintentionally advocating for something.
Okay.
Erica?
I did see a question come through,
Thank
but I
you.
didn't catch it. Can you
The question is, would this include a current board member putting a sign in their yard for someone running for school board?
So the current school board member is putting this in their own public-private or their own private property, right? Their home, they're not putting it anywhere in the school. I mean, you don't, as you're still allowed to participate and have your First Amendment rights. The issue is making sure that you're doing it. You're not using government resources. So if you're advocating for another candidate, you're doing it on your own time. You're not doing it at the school district. You're not doing it during a meeting. If you have a sign, it's in your private yard, your home. And if you're utilizing any resources, time or things, it's your own time, your own personal resources. You're not, just because you're that school board member doesn't mean that you can no longer participate in the political process. You just can't utilize your public resources that you have as a benefit of being that school board member from doing any of that. So you would need to make sure that you're using your own personal phone line, and you're not utilizing school district letterhead, those kind of things. Not putting anything up in the school, not doing anything during the time you're supposed to be working on school issues.
Okay, great questions. Thank you, everybody, for submitting those. We're going to move on to considerations for candidates, because candidates will want to consider the legal, ethical, and financial aspects of their campaigns. The school board candidates, as school board candidates, you must comply with the Iowa Ethics and Campaign Finance Disclosure Laws, and those are located in Chapter 68A and 68B. So there are many, many provisions of this law, but for sake of time and respect of your time as well, we're just going to hit on those or highlight the heavy hitters. So I'll pass that off to Erica and Bailey.
So candidate committees, so we, at the Ethics and Campaign Disclosure Board, we have what we call the WRS, which is the web reporting system. And with that, you can file any of the reports that are necessary as a candidate. So any individual or PAC, committee or candidate that has met the $1,000 level is required to file a report with us, a DR1 report with us. It needs to be done within, I believe, 10 days of meeting that $1,000 threshold. So even if you are completely self-funding your own campaign, if you spend $1,000 on yard signs, on brochures, those things, you are required to file that candidate committee. So keep in mind with that, that $1,000 level is kind of where you are required to file. You can file before that without any problem, but you do need to make sure that you do file once you reach that $1,000 level. The attribution statements, these need to be included on anything that advocates for a ballot issue, that advocates for a candidate, for or against a candidate. I will say, since I started in this role in the summer, and I have received a lot of calls about attribution statements, people forgetting to put those attribution statements on campaign flyers that they are handing out. So this is something to really think about. You do have to put an attribution statement on anything that expressly advocates for an issue or a candidate. The only thing you don't have to put that on is yard signs, clothing, or very, very small things like pencils. But anything else needs to have that attribution statement. If you have not filed a DR1 creating a specific committee, then you would need to include the name and address of the person who paid for that that specific document or ad on Facebook. There's a guidance on our website about how to address, a lot of campaigns use Facebook advertising now. They have Facebook pages, they have web pages. So there's a lot of information about where to put those attribution statements for a website that's paid for by the campaign, for Facebook pages that are put together by the candidate or their volunteers. So you need to make sure that those attribution statements are included. Again, we're getting a lot of people will send us pictures. I just received this in the mail. It doesn't say who paid for it. So people are watching, and that is something that we will require you to go in and fix. So keep that in mind. The reporting requirements when you hit that $1,000 threshold, and then at certain times after the election, depending on the race that you're in, the attribution statements for anything that you are printing or paying for aside from those campaign signs. And then Bailey, I don't know if you wanted to chat a little bit about campaign signs, if you want me to take it, how you want to do that one.
Yeah, I'm happy to talk about that. Our office gets a lot of phone calls about where can this sign be? Does this need to be taken down? We proactively train law enforcement and the county auditors about what electioneering means. So electioneering is defined in Chapter 39A of election misconduct, and specifically campaign signs. That's in 68A.406. So that will lay out how where campaign signs can be posted. So the big ones are, there's a difference between a private yard and the public right of way. So the space between the sidewalk and the road, that's a public space. That's not your private property. So if you're gonna have a yard sign, it needs to be on the other side of the sidewalk, on your house side of the sidewalk, because between the curb and the sidewalk is a public space. So in that same vein, you can't put any campaign signs in any public place. Government property, a public park, it has to be on private property. That being said, you can always have like a bumper sticker on your car. So basically I don't have it pulled up right in front of me to tell you exactly what the measurements are, but it's basically like, you can't have anything larger than an 8.5 by 11, like a regular letter size piece of paper. Once it gets beyond that, then it becomes more than just a bumper sticker. And you cannot have anything within 300 feet of the entrance of a polling place. Again, unless it's on private property. So all of our counties have received through the Department of Administrative Services here at the state, they have provided GIS maps for all of their polling places, and they have 300-foot maps, and they know exactly what that 300 feet looks like. And the poll workers are trained on it. Again, the law enforcement, the county sheriffs and deputies are trained on this. But this is one of our more common questions that we get from the public about campaigning. We have a question is, when do they have to take the signs down by? And unless there's a city ordinance, they can stay up forever. It's their private property. So yeah, we get a lot of concerns about signs. And again, those two parts of statute that I just said to you, 68A.406 and then 39A.4 will cover all of it, but just keep them in the yard, keep them close to the house, and make sure that you're extra careful around election day. But other than that, we should be good to go.
I'm just gonna jump on that. The other thing, make sure, and this seems common sense, but make sure that you have permission to place that on a person's private property. And then you need to make sure, as Bailey said, it needs to be a private property. It can't go on a prohibited contributors property. So corporations, banks, insurance companies. So it needs to be in that private property. We also get a lot of concerns about campaign signs. So we do have a form that we fill out, or that people can fill out on our website, providing specific information about a campaign sign if there is a concern, and that link is right there on that web page, or on that PowerPoint slide there, so people can fill those out, and if we have the information, we can call and try to address the concern with the campaign signs.
We do have another question related to signage. What businesses can we put a sign on if we have the permission?
So specific limited liability companies that are not owned by corporations and family farm corporations. I would say, if it's a limited liability company, Secretary of State would have, you guys have a great database if there's concern with that.
Yeah, you can always reach out to us, and figure out what a business is incorporated as. But I'm just perusing the code, and, prohibited, contributors is 68A.503.
So a limited liability company, LLCs, it used to be pretty small families. Right now, even Google, I believe, is an LLC now, but that would be incorporated. So an LLC, the Secretary of State's office would be able to talk about different types of business entities, but typically it's small family-run type LLCs that are not incorporated.
I wish I could give you more help on this, but I live in the election side of the office, not
Yep.
the business services side.
So, but yeah, I mean, if somebody has incorporated, it kind of depends on if they're registered with the state, or if they're, typically if they're registered with the state, they're either an LLC or they're incorporated. Again, that's a very broad, very general statement.
So another guest has just another clarifying question. Restaurant, boutique shop?
Again, it depends on if they have chosen to be incorporated as a corporation, if they are just and again, I'm not a business attorney. I would say if there's concern about a company, I would check the database, the Secretary of State's database, to see if they are incorporated. If they're a sole proprietor where they have not filed anything, it's just the individual operating as a business, that is not included. But if they are, if they have filed those papers to incorporate with IRS, insurance companies, and then they would. If they're sole proprietors and they have not, LLCs have not been included in the code. So that's why some of them are allowed.
If you have any concerns, feel free to reach out to either Erica or myself, either of our offices, and we can get to the bottom of it and figure it out. We just want to make sure that you have that heads up to know.
Yeah.
Don't get yourself in hot water if you don't need to.
Yeah, the best thing to do is to, if an individual is going to support you, have them support you on their private property.
Great questions, guys. All right, so moving on to why is it important to comply? Penalties. So this is the portion where we're going to ask the audience to think a little bit. We're going to explore through some kind of interactive scenarios and cautionary tales. So here's our first scenario. I will read it out loud and then kind of let the audience think about this for a while. And at the end, we will have answer options, and we'll have Erica come in and kind of give her thoughts on the two options that are available. So scenario, a citizen in your district is also running for an open seat on the same board. They ask you to run as a block or a group to share brochures and signs and to campaign together at events. So sort of sit there, think about this scenario for a while. Our options here are what would you do? And there are two. So yes, I'll run as a candidate block. This seems easier than running on my own. No, thank you. I'd prefer to run my own separate campaign. So sort of think about those options, and I'll give you maybe a couple minutes and then invite Erica to speak to this. Maybe just 30 seconds. Erica, would you like to talk?
Uh, somebody is asking to go back to
Oh,
the last slide so they can see it
yes,
again.
of course. So here's the answers. I'll let you everybody kind of look at this first, and then maybe we'll go back to the last slide so we can look at the scenario while Erica talks.
So this is legally, you should not do this. That's a very short answer. The Iowa Code each campaign a candidate is prohibited from providing funding to another candidate. So if you're running as a block, you would likely be in violation of this because each candidate needs to pay for their own brochures, your own signs. And so if you're running as a block, you would not be a specific candidate. You would be paying for another candidate, which is prohibited under the law. You are allowed to have joint campaign events. However, each candidate needs to pay their own portion for the costs of that. So we exist for the transparency in who is what is spent on elections, who is providing the funding for that. So any of the candidate funds that they're getting from fundraising or they're funding their own campaign, all of those are part of the reports. And so you would have to include all of the money that you have brought in to help finance your campaign. Each individual over $25 needs to be included in the reports. If you're running as a block, then you are helping support another candidate. One candidate is supporting another candidate. Like I said, that would be inappropriate under law and would not be allowed under the law, and our auditors would be flagging that and contacting you. The joint campaign, you need to make sure that each person is paying for their specific things. You need to have whoever's assisting with that, whatever the cost of it, maybe send bills to each of the different candidates so they can pay individually. So in order to have that transparency of what each candidate is doing to prevent the candidate funding another candidate, this would not be something that would be appropriate legally. And I think, Anna, you were going to talk a little bit more about even beyond the legal aspect of it.
Yeah, and I think this actually kind of speaks to one of the questions that just popped up in the chat. Campaigning as a block with free advertising. It'll sort of touch on that. So we have the legal, or is it wise? So we really have to think about, although maybe something is legal, what is this going to look like from a public perception? What is this, or how is this going to impact you? Should you be elected or not elected in the future? So the questions that we have here on this slide, and often that we hear from IASB, this is pulled from feedback from past board members and citizen calls that we've received from potential candidates. So as we read through these questions, just try to think about beyond the actual campaign and into those future implications. So if I run as a block or a group, what might the impact look like? So let's say you win, but the other two candidates in the block with you did not win. So how might this impact the relationship you have with other board members who are not a part of that group? And that's more of a relational, kind of a PR, personal relations consideration. So running as a block could also set up group expectations. So for instance, just kind of a quick example, one of the three, say it's a group of three, one of the three of the people promises to do XYZ. They're taking a really strong stance on this position or on this issue. And maybe you just don't agree, or at least you don't have as strong of opinion on this issue. So how might that impact the public's view of you, or what assumptions, I guess, could be made regarding your opinion if one person of the block is speaking one way and really you're trying to advocate in a different direction? So another example, we're thinking post-election here. So you're kind of caught in a dilemma if you end up at the school board, and maybe you've learned a little bit more about what it's like to be a part of a board. So say 3 months go by, you've been a board member for that amount of time, you've learned a lot about school finance and bond referendums. This is information you may not have known as a candidate, and now it's starting to impact the way you vote on a certain subject matter. So this is where that dilemma lies. Many of your constituents or fellow members of the block assumed you may have been voting one way, but now that you've been exposed to more information or become more of a seasoned board member, you've decided, oh, this may not be the direction I want my vote to go. And you'll have to kind of ask yourself, what does that look like to the public eye? How does that set expectations? Yeah, just things to think about on the legal or is it wise perspective. Okay, so we are going to move on. All of the information that we have learned today, this isn't just kind of a sit and get, this actually happens in real life. So this is the portion of the presentation where we invite Erica and Bailey to share some of their cautionary chairs on these on this subject matter. So I will pass it on to you two.
Bailey, you want to start?
Yes, I sure can. So I already mentioned this earlier in the presentation. Get more signatures than you need. In our office, we're the filing officer for statewide and federal races. And so we deal with some pretty hefty binders of petitions when we get them. But it translates directly to local elections like school boards. When you show up with just the number that you need, somebody's going to find something that isn't quite right. They're missing the city, or they didn't put the ditto mark in. Oh, I will say ditto marks are okay, but just remember that they ditto what's directly above. So if you have ditto, 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 blank, ditto, they ditto the blank, that would be crossed out. And now you have one signature that you needed to have to meet your threshold. So always go above and beyond, get an extra 10, an extra 15, an extra 50, whatever the case might be, depending on your the size of your jurisdiction, but just get more than you need, because there will be objections. An objection panel will be convened and they will decide whether or not to count the signatures. We see this a lot more commonly than we have in the past, which is, I think, kind of a sad state of affairs that, but at the same time, you know, everything's under scrutiny, and when things are under scrutiny, that means that they are being reviewed and addressed and dealt with. So I retract that statement, but and just another reminder to turn in your paperwork to the board secretary, not to the county auditor. I know that your city people that are running for your city council or mayor, they might be turning it into the city clerk or to the county auditor's office. It's different in every jurisdiction except for school boards. School boards always turn things into your school board secretary. So turn them in early, because they will then take a look at it and say, oh, you're missing this, or oh, your nomination petition header was wrong, so you have to go back and get another 50 signatures because this isn't right. They'll look at that when you turn it in, so then you're not, you know, you don't have enough time to go back and get the extra signatures that you need. This happens way more than I would like to admit, but it happens all the time. So I will turn it over to Erica for the other cautionary tales.
Yeah, so these last two we talked about under the conflict of interest, how you cannot use government resources for your express advocacy. So if you're sending campaign emails to school emails, those school emails are public resources. I will guarantee that if a campaign email is sent to a school email, we will receive a copy of it. People do send it. We get questions all the time. Are they allowed to say this to us? Are they allowed to send this to us on our emails? So do not utilize it. Remember, if you're campaigning, utilize the private resources, private emails, those types of things. Similarly, teacher mailboxes are government resources. Sending campaign mail to that, it would be in violation of Iowa code, which has that prohibition against using government resources for campaigning. Again, I can guarantee that we will receive a copy of it and we will know who sent it. And so you would be hearing from our office on that. So just make sure that if you're sending out campaign emails, it's going to private emails. You're not using the teachers' mailboxes to send information about express advocacy for ballot issues or for specific board members who are running for office. I saw a question pop up, but I wasn't able to read it fast enough.
Thanks, Eric. I'll get this for you. If the candidate answers the running to fill a vacancy due to death, etc., wrong and crosses it off, are those papers okay?
You shall not change a nomination petition header after signatures have been collected. So if you have signatures on that paper that said, I am running to fill a vacancy, and they realized, oh, shoot, I'm not, and then they try to cross it out, all of those signatures are null and void. Get it right the first time. I that might sound pretty harsh, but the people signing your petition need to know what they're signing. And there's a little bit of wiggle room where it's like, well, okay, if you left it blank, if you didn't check yes or no, but there is no other position on the ballot, then obviously, it doesn't really matter if it's to fill vacancy or not to fill vacancy, but I will really truly die on the hill of you do not change a nomination petition once you've collected signatures on it. That invalidates the signatures.
I'm just going to add this. I don't know if it was meant as an additional question, but this board secretary also commented, I don't know if it was crossed off before or not.
I would say if it's crossed out, that would say to me that it was done after signatures were collected, because if it were before signatures were collected, you would have just used a new sheet and used a new page. But these are the kinds of questions that unfortunately don't have really great answers, because I feel like I say this a lot. Iowa law does not contemplate what happens when it's not followed. So there isn't always clear guidance on, well, what happens if this wasn't done? Like, well, then I guess it goes through the court. So in this situation of I signed a petition, but it was crossed out, I'm not sure when it was done, those petition papers could be objected to and presented to an objection panel, which is laid out in law, and they would review it and take in evidence and make a decision from that. But Iowa code expects to be followed, essentially. And we don't have a lot of mechanisms for fixing it when it doesn't. So you got to get it right the first time. And because if I were an objection panel and I was presented with nomination petition pages that could have potentially been altered after receiving signatures, I personally would go ahead and throw those out, because I would like to have a clean, fresh, correct nomination petition in front of me that I'm signing and then receiving as a filing officer. So I don't have a great answer for that, but again, get it done right the first time.
Okay, so I do see we have some questions coming in, but we are running up on time, unless Bailey and Erica wanted to stay a little longer to answer some Our contact information is part of these slides. Our communications, ISB's communications team has a wealth of knowledge on election questions, and we also have an board election toolkit that is open to the community. Yeah, it looks like we actually have quite a few coming through. If you wanted to,
Yeah, I can hang out for a little bit.
okay, yeah, that sounds great. Otherwise, yep, feel free to email or contact us. I am going to throw up this resources page quick, so we can look at this while we may answer a few extra questions. Bailey, thank you. Erica, if you want to stay longer, you can, but otherwise completely understand. Want to respect time.
I'm happy to stick around. I think most of the questions are for Bailey, but I'm happy to stick around.
Objection panel laws are, I want to say chapter 43. That's the primary chapter. I think that's where a lot of them are. 49 also. We can, if you have specific questions about school board objection panels, I can find that, but just email me. I'm not going to dig it up right now. If the header information was typed in the form and printed, and then the candidate wrote in the district name, that's fine. Yeah, it doesn't have to all be printed out, you know, from a computer. I mean, you can absolutely handwrite things. The point that I wanted to make was you can't go back in and change things afterwards, but completely understand that, yeah, if you, because at the state level, right, you have everything printed out and then you have to handwrite in the county. So that's totally reasonable. Crossed out address by a citizen, should they go to another row? Can they write above it? Either. Yeah, there's nothing, I mean, yeah, either way is fine. They can, if there's room to get it in there and be legible above it, they can. If they write it in the row below, that's fine. It just that row that's crossed out is not going to be counted by the counters dealing with the signatures. Given that this is now
I
a
can take that one because I think there's some
Okay.
misunderstanding. I believe that you're referring to the open meetings, open records law requiring training within 90 days of being appointed or elected to your position. And I know you guys have something, and I know IPIB has that training, but I don't, this would not apply for that.
No, that training is wholly separate from election informational presentations, which is what this is. Open meeting laws and open record laws are separate, but ISB will be providing a virtual option if this is the question or the direction the question is going. We will provide a virtual option. It is in collaboration with AEA Learning, and that would be a one board member at a time training, and that would have to be requested and registered, etc. And then otherwise, there should be other options in the future for that training. Oh, how do I get that training? So, yep, as I said before, that virtual training for ISB is under development. We also hopefully be offering a closing session at, and I'm unsure if the question is coming from someone who is newly elected or not, but that training will be hosted at ISB's annual convention, also known as BoardCon, at our closing session, so we can provide that to a larger audience. And then if anyone's familiar with ISB workshops, we're also hoping to create a training that's very similar or runs parallel to the workshop training and meets those legal requirements. As Erica
And
said,
also,
oh, sorry, go ahead, Bailey.
I was just going to say that also when you receive your notification that you have won the election, you also receive a copy of chapters 21 and 22, which are the open records and open meetings chapters of Iowa Code. The county commissioners, the auditors are required to send that to you along with your winner certificate. So yes, training is amazing and should happen 100%, but you do get the actual physical chapters 21 and 22 that do cover it. And I always try to tell people that the code is not as scary as it seems to be. It's pretty readable.
Yeah, so as far as getting that training, to Bailey's point, it is important to become familiar with those code sections on your own time. And also there's just a variety of ways to access that training through IPIB, through ISB. There's other organizations and that I know have applied for facilitating that training. And so if you really want to, just reach out and we can easily find or at least ISB can find the best direction for you on how to access that training. But yeah. If there's no other questions, I think we may wrap up and give a big thank you to Bailey and Erica for taking time to offer us all of this information. Again, here's the resources and reach out if you have any other questions. Thanks, everybody.
Thank you,
Thank you.
everyone.
Appreciate the opportunity.